Yeah, I see it as materially different.
Would you care to make a motion to that effect?
Make a motion that we hear case 4017, based on the fact that it's a new request. It's materially different from case 3017.
All right, is there a second? Second. Is there any discussion on the motion? All in favor?
Aye.
Anyone opposed? The vote is unanimous. The board considers this a new case. Please proceed.
Okay, so I'm just going to start by saying that the discussion 2 months ago really centered around the diminishing value of the property to the rear. I'm not sure that that neighbor is here tonight, but I do want to point out that Bill Norton is a commercial broker. He is in the audience, and he will speak to that issue if it's something that the board would like to question him. He's here. So I would just, for the sake of essentially the application and the merits of the application for the appeal are materially the same. I can read through those again to enter them into the record, or we can just sort of...
I think they're in the record. What I'd suggest you do is explain why this, in general terms, why this particular proposal with the addition on the west side of the building, which is where it is, correct?
Yes.
So complies with the requirements for granting variance.
Great. I'm going to, I'd like to enter this into the board. Craig had asked me to bring copies of support. There's actually letters from the 3 abutting property owners. That's the Sharon Gamble, the ladies that live to the west, which we share the driveway with, a letter of support asking you to approve the appeal. Peter Milnes, who owns Inex Properties in the parking lot to the east, and the Y that is directly across the street. So this proposal is essentially proposing to add a 12 by 28.5 foot footprint to the west side of the building. And there would be it would also, when built out, would actually enclose an open-air porch that exists there today. This is a 2-story proposal within 2 feet of the property line. Craig and I did have some conversation back and forth, and there was some issue of where that property line actually exists. Sharon Gamble, the neighbor, actually provided me with Bernier sheet. He had actually staked the corners of her property and defined and put a pin in the driveway so that we could physically locate this. I actually laid this out so that the girls next door could actually see what the footprint would look like in the parking lot. That pin is found and noted on the plan. Essentially to go back, I'm just going to read a couple of these things here in terms of owing to the special conditions of the property. The property along Warren Street and Blake Street are small and they're heavily developed. The project site is bounded by abutting development on the sides and rear within the setbacks. Non-conformity on these lots exist on almost every lot along Warren Street and Blake Street, which is the party property lines. Most of the properties in the neighborhood are non-conforming, heavily developed. Most dimensional requirements cannot be observed, as most properties are presently non-conforming. Applying the dimensional requirements to the subject property would be unfair, given that they are not observed on the abutting parcels. It's reasonable to expand in place rather than relocate our existing business when only a modest amount of additional square footage, a total of 827 square feet over 2 floors, is needed for us to remain. I mean, I'd ask the board to consider that. The professional office space is permitted in the district and the dedicated off-street parking is available. With this proposal, there are currently 7 parking spaces, 2 of which have been taken up with the shed in the back, which will probably remain at this point with this proposal. But the parking, I currently get 5 cars in the driveway. It would be reduced to 2 9 by 18 parking spaces and allow me to park 2 spaces in front of this addition. We rent space from the Inex lot on the corner, and we'll probably increase the number of spaces that we rent from them, which are available. So I don't see that as a problem with my business being in the building, or should I lease it to somebody else in the future. The CVP district is intended to promote transitional office space between the central business district and the downtown residential district. The district also features an adequate supply of public parking. There's a public parking garage directly behind the Y that my staff uses on a regular basis. The actual lot coverage of this proposal, a maximum lot coverage allowed here is 80%. The existing lot coverage is 74%. The proposed lot coverage actually becomes less. It's about 65%, because I will remove all of the pavement that extends all the way out and around the back of the building. So there'll be more green space, actual lawn in the back of the property. I've reviewed the concept with the ladies next door. They're very supportive. And I think it's a fair and equitable application, and I'd ask the board to vote favorably for it.
Questions from the board? Nick?
No.
Chip? Rob? Thank you. Andrew, did you have any questions?
But if you share, so I assume that you're not taking up any of the, if you share a driveway with the neighbors.
Two separate parcels. It just happens to be both driveways are paved to property line to property line.
Oh, so you're only taking up the portion that's.
I have the left side, they have the right.
Okay, so it's not taking up any of the driveway that they use?
No.
I got it, okay.
It's not encroaching on their property at all.
And I remember the big issue before was the south neighbor was really worried about the view. That the earlier addition would obscure her view from her deck. We don't think she's here, but have you had any feedback from her about this plan? Do you have an opinion about that? Will this be as much of a problem for her view?
This doesn't encroach any further back than the existing building, and she'll continue to look into my backyard.
Yep, okay.
Other questions? Thank you very much.
Yep.
Is there anyone who'd like to be heard in favor of this appeal? Please come forward.
I'm sorry.
Please come forward. Did you want to be heard?
I do, but
Please come forward.
I think I'm in favor.
Well,
I am the neighbor to the south.
you don't have to sign up in favor or opposed. You can just come on up. The seats to my right. Could I swear you in?
Oh, yes,
Swear to tell the truth and nothing but the truth.
I do.
Would you identify yourself for the record,
Karen
please?
Maynard.
Would you have a seat?
Sure. I just want to know the footage, the setback from the new addition.
To the side yard?
To the south property line, backyard.
It's not on this drawing. Mr. Halley, can you fill that blank in?
Well, can we show it?
Greater than,
From the last point.
it doesn't sit, not as far back as the existing
Chris,
building.
when I was showing a picture of this new dike,
It doesn't have a dimension from here to
Then I have
here.
no
but I
objection.
think I could show it as being close to the lot line.
Hope you have happy holidays, and I'm done.
She was talking about
Thank you.
south.
Yeah, that's.
Yeah, I guess she's all set.
But. Well, thank you for your testimony. Is there anyone else who'd like to be heard in favor? Is there anyone who'd like to be heard in opposition? Any comments from code enforcement?
Well, just a piece of information that was not brought forward at the previous meeting is this was originally granted a variance to be able to convert from a residential to a commercial property back in 2000. That variance was to permit 6 parking spaces in a configuration of this nature where 8 would be required. And so that's what was represented to the board at that time as being the hardship or the issue or needed for conversion to a commercial property.
We,
At that point, was that the CVP?
Similar type
Gotcha.
zoning district, yes.
we do have some letters. There's a letter here from Sharon Gamble, 29 Warren Street. Having reviewed the proposed building addition to Warren Street Architects at 27 Warren Street, we, the owners of the building at 29 Warren Street, approve of the addition. Warren Street Architects has been our neighbor since 2000, and we appreciate their presence across our mutual driveway. We ask that you approve their request to build the addition. There's also a letter here from Bill Norton of Norton Asset Management, who is, I'll paraphrase this to some extent. He's been asked to look at the question of, let's see, he has looked at several properties on behalf of Warren Street or with Warren Street around town and attempting to find a place for them to relocate their office, and they have been unsuccessful. They exhausted multiple alternatives, and this variance request is a result of their inability to find other places that are suitable for their business in the city. I got the first page of Mr. Norton's letter. Let's see if anybody got the second page, where the good part is. Here we go. He's been asked to assess the impact on the property values of the abutters. The answer is an unequivocal no. Investment and expansion of existing uses in the civic performance zone and the central business district are a betterment, not a detriment. Investment adds to property values. Streets and neighborhoods that are improving and gaining investment increase in value and attract more tenants, either residential or commercial, office, service, and retail. The proposed project is an improvement and one that should be approved. We, the community of Concord, need to encourage investment in these districts to achieve vibrancy and spur more rooftops to feed off the Main Street investments to achieve the vision for a robust and growing downtown with significant arts and design component. The expansion will bring more workers to Concord's downtown. We also have a letter from Peter Mills of Woodbury Court, LLC. He's writing as a direct abutter, owns the parking lot immediately to the east of 27 Warren Street, and he indicates that he is in favor of the appeal. They have been a good neighbor. And finally, I have a letter from James Doremus, the Chief Executive Officer of the YMCA, who is their neighbor across the street. And he says that they feel improvements to the appearance of their building raises everyone's economic property values and shared commitment to the neighborhood. They support the approval of the variance request. Now, these letters are all dupes, correct?
Yes.
With that, we'll close the public testimony portion of the hearing and open it up for discussion. We heard a proposal to add to an existing building on a tight site downtown, immediately to the south of that building. Any addition to the building would require invasion of the setbacks. We heard testimony that the neighbors whom are most immediately impacted have no problem with the proposal. Discussion.
Quick, guys, just to make sure I understood what you were getting at, the earlier variance was to allow fewer spaces than would otherwise be required. Is that, and now you're saying that it's going to be even fewer than what they had originally proposed?
Correct. The original proposal for it showing 6 parking spaces to accommodate the commercial use. And so now this proposal is reducing it to maybe 2. I haven't seen a final plot plan, so I wrote it up as not less than 1.
So are you suggesting they may need to get another variance now for fewer parking spaces, or that's?
No, that's all included.
It's all in the.
Oh, that is included.
Yeah, those are the ones
Okay.
regarding all the parking there, yeah.
Oh, I see. So they need an additional variance for that. Got it.
I think in regards to the parking, they mentioned that they would lease more space from that vacant.
Yeah, from the lot
It's
next
on the
door.
east of the building, I think.
Yeah.
East of the property.
There was one clarification also I would like to ask of Mr. Halley. My recollection is in your earlier proposal, you indicated that you're not proposing to change the size of your staff. Is that still the case? Okay.
I was just going to say, however, it could be leased in the future. So-
By someone who, yeah, who did.
Sure.
I actually had a question for the applicant. Is there handicap parking available to your business today?
No, this business is not handicap accessible. Finished elevation is about 5 feet up from Main Street.
Thank you.
Discussion? Nick, do you have any thoughts?
Well, I remember the last time that our biggest issue for some of you was that the proximity of the original proposal to the rear lot line. The rear lot line seemed to have been a major concern to, and what I see here is I see the same size addition that we had no problem with being relocated in a less intrusive way, number one. And number two, I'm seeing that this could be less non-conforming use by the removal of pavement to the rear. So I think we're improving the condition of the lot coverage, number one. And number two, we've eliminated, I think, this board's concern about the rear lot line intrusions. So based on that, I would move approval.
Is there a second?
Second it.
Moved and seconded. Discussion on the motion.
Yeah, I have a question for Craig. Can you explain to me better the variance 2E to provide no on-site accessible parking?
That's basically it. Under the requirements, one van accessible space must be provided, and so they are not proposing any accessible on-site parking at this point in time.
And why is it that the current business is not required to provide?
It was
Other
approved
than
under a
was it-
prior ordinance. I'm not sure if the accessible parking was required at that point. So in 2000, we adopted the current ordinance in 2001. Accessible parking is required both under the zoning ordinance and under the international building codes. So.
Was your motion, Nick, as to both variances?
Yes.
I agree with what Nick said, and I would just add, as far as the parking goes, in that area, I think this is a reasonable use of their property to develop it as much as they can creatively, and because there is parking nearby and there's lots in the area that visitors can park, or street parking that people can reasonably park, I think that's also a proper variance.
Any other discussion?
I know there's some complexity to how we got here, but I'm going to vote no because of the provision 2E. It doesn't strike me as though the applicant took, I could be wrong about this, but whether there was any effort to try to provide accessible parking when it would have been required.
Other discussion?
Well, should we? And I don't know if you want to divide the question.
We can, well, yes. Why don't we do this? I don't think we can separate E out. Well, I suppose we could, because those are variances. It says A, B, C, D, and E are all separate variances, correct?
So the building
Yes.
is not handicap accessible, so
All right.
you think we need a...
Well, what I,
So was my question, Craig. It strikes me that it is required, and if they're here asking for a change in the building, it would be the opportunity to get it back up in compliance.
okay.
Depending on the amount of work being done on the building too, they may be required to.
And I didn't hear anything from the applicant about why they chose not to find a way to address that requirement.
All right. Procedurally, what we can do is, with the permission of the board, we'll go through these items individually. Now, what we'll need to do then is withdraw the motion, the earlier motion, and have a new motion to segregate the votes.
So I'll withdraw my motion and modify to just item 1.
Okay, is there a second for item 1?
Second it.
Is there any discussion on item 1? All in favor?
Aye.
Anyone opposed? The vote is unanimous. Let's go then to a motion for any of the items in item 2, and it sounds like what we ought to do is at minimum segregate E.
So I would move to approve variances 2A, B, C, and D.
Is there a second for that?
Second.
It's been moved and seconded. Is there discussion? All in favor?
Aye.
Anyone opposed? And now, do I hear a motion for 2E?
I will move not to grant 2E.
Is there a second? The motion fails for lack of a second. Is there another motion?
I would move to approve variance 2E.
Is there a second?
Second.
Any discussion on the motion? All in favor?
Aye.
Anyone opposed?
I'm opposed.
The vote is 4-1. The motion carries. Mr. Monahan in the minority. Next case this evening is case 4117, Petrogas Group of New England Incorporated. The applicant wishes to add approximately 567 square feet of building area to an existing retail use and requests, first, that the board overturn the zoning administrator's decision that, in accordance with Article 28.7 access, circulation, parking, and loading requirements, Section 28.7.1, general provisions, Section A, applicability, if a building or structure is constructed or enlarged, off-street parking and loading will be provided for the entire use or uses in accordance with the provisions of Article 28.7. If the board upholds the zoning administrator's decision, the applicant requests the following. 1, a variance to Article 28.7.7G3 parking to be located to the side or rear of the building to permit the continuation of vehicle parking in front of the building between the building and the street, where parking is required to be to the side or rear of the building.
2 maps.
And second, parking lot perimeter landscaping requirements to not provide the required 10-foot parking lot perimeter landscaping along a portion of the front property line between the 2 access points for property located at 417 South Main Street in the CG General Commercial District.
So
You swear to tell the truth? So help you God.
I do.
Of course, there's only 2 with maps on them, so that's
Okay.
yours. And then yes.
Would you identify yourselves for the record as you testify?
Yes,
please?
Mr. Chairman, members of the board, my name is John Cronin. I'm an attorney with Cronin, Bisson, and Zelinski in Manchester, representing the applicant. With me here tonight is Ms. Nicole Duquette. She's the project engineer who has done the design work.
Fire away.
The first thing before you is, as you correctly noted, I invite the board to undertake a Bartlett analysis that springs out of the Bartlett versus Brookside case, which you may or may not have done in other matters. I don't appear before this board often. It's been many, many years, in fact. But since the decision in Bartlett versus Brookside, the Supreme Court said that the zoning board has the power to determine in the first instance whether or not a variance was even required. Back in the days when I started, you need to initiate that by an administrative appeal, but they did away with that, and it's referred to now as the Bartlett analysis. The basis for that argument is basically that the project, acquaint you with it, you're probably all familiar with it, is 417 South Main Street. You can see it here on the board. What they're proposing to do is add 2 small spaces here. This is at the entrance, and this is a cooler that will be on a pad in the back. The issues that came out in zoning review that were called to be non-compliant were the lack of the 10-foot perimeter buffer along the front and parking in front of the building, which if we were to build this site today would not be allowed. However, this site has been in existence and its configuration is shown on the screen for many, many years. And there's a distinction in your ordinance between a non-conforming lot and a non-conforming use. This use is allowed in this particular zone by the ordinance. But if we look at the lot, you could say, yes, this lot itself is not conforming because the parking's in front and you don't have the 10-foot of landscaping buffer. In 28.8.1 of your zoning ordinance, it talks about non-conforming uses and treating them as distinctly different vis-a-vis the use or the lot, which draws my attention then to 28.8.4, the section which talks about non-conforming uses, and we believe that we comply with all of those. I'll go ahead and read them just so that's on the record. Continuation of a non-conforming use and non-conforming characteristics of a use. Where a non-conforming use or where non-conforming characteristics of a use such as off-street parking and loading, lighting, landscaping, or similar features exist, nonconforming uses or characteristics or any use may continue so long as it remains otherwise lawful, provided that. And it goes on to 4 different characteristics. One of them, the general sense, if you're not enlarging it or increasing the size of it, or you haven't abandoned it prior to coming in to seek permission, you qualify as a nonconforming use. Here, the front is not going to change. That area is not going to be increased or enlarged in any way. What is going to happen is one of those parking spaces out in the front, I'll show it to you over here, that's going to be designated for handicap. There's no handicap parking that exists now. And also as part of the updates, the bathrooms here that are on the left side of the structure, they're kind of the old-fashioned bathrooms that face out to the parking lot. You have to come in and get a key, which are not really designed for control or safety or for handicap access. So they're going to be spun around so the access will be in the front, and these bathrooms will become ADA compliant. When you look at the site from the back, there is an easement along the back line. It's a utility company down and back, so they have the rights to the back of that lot. So basically what the goal here is to try and spruce up the facility. I recognize that, again, if we were starting today, it would be proper to say we don't want to see the parking in the front, and we want to see you have the 10-foot perimeter if you could do it. Where this has been long existing, we believe it's a classic non-conforming use. I'm sure you're all familiar with that area if you went out and looked. These frontage strips where the bushes are located now, they're pretty consistent with most of the commercial businesses along that strip. This doesn't look unusual, extraordinary. Up on the plan here, it looks like that there might be some green area here, but that's a steep elevation. If you don't see fit to consider these non-conforming uses, we've also applied for the variances. We've laid out in our application the 5 criteria for each. We believe that we meet them. I'll waive the reading of each one of those criteria and rest on our written submission. But basically, this is not going to change in any way. We don't believe there'll be any detriment to any abutting properties. This is a commercial zone. It's a commercial use. It's not going to be changing whatsoever. Is it in the spirit and intent of the ordinance? Yes, it is. You want to have commercial uses in this zone. This is the type of use that was called out by the drafters. That is going to continue. The work that's going to be done will make the facility better because it is providing some handicap parking, which is a goal of every community, and making the bathrooms more safe will also dress up the facility. As far as the substantial justice prong, I know that's always a subjective one when you take a look at it. And as far as the harm to the applicant, the denial of these variances will make it difficult for them to do what they want. They definitely need the parking. It's essential to what they do. And if they can't have it in the front, you see you have the canopy to the other side and a steep elevation on the other. They really couldn't continue operating their business. As far as the hardship prongs go, if you look at it, is there a fair and substantial relationship to the ordinance? We think we meet the ordinance, and this is an unusual one for me to make because we think it's non-conforming and it's prior existing. And we believe that the use that we're putting is reasonable in the sense that it has existed there since, I believe, the 70s. If you have any specific engineering questions about the design and what's going to happen, I'd let Nicole address that because she's much more capable than I.
Well, before we launch into that, I'd like to address the first issue, which is your request for us to overturn the zoning administrator's ruling. Because assuming we do that, the rest of it is moot.
That's correct.
Could you explain the logic? My understanding, and I'm going to ask Craig to chip in on this as well, but my understanding is that the reading from Code Enforcement Administration is because it's a non-conforming use and you are expanding it by adding to the side of the building, that triggers a requirement that you comply with the requirements that you don't conform with or get a variance. Now, do I have that correct?
I believe that's the call of the zoning review.
And from your written submission, it wasn't clear to me how the Bartlett decision applies in this case. Could you explain to us why you don't believe that the changes that you're specifically proposing here trigger that requirement?
Because none of them are non-conforming. They're all zoning compliant, plain and simple.
So your reading of the ordinance text is that the changes have to be non-compliant, not just that there be a change to a property with non-compliant uses.
That's correct.
Okay, so that's the distinction you're making.
Yes, there's no, the addition that's being put on, they meet the requirements of the zoning ordinance.
Setback and everything else.
There's no variance required for those.
Okay. Craig, could you chip in with your thoughts on this, please?
Sure. There's a couple of things, and I'd just like to continue on with 2884. Well, again, the use is conforming, and it's not the use itself. It's the layout of the property that is currently non-conforming. And under this non-conforming uses of land section, Article 1 says, you can swap one permitted use for another permitted use. And if the parking requirement is the same and there's no ability to improve the parking, then you can swap one for the other, as long as no such non-conforming use or non-conforming characteristics of a use shall be enlarged or increased nor extended to occupy a greater area of land than was occupied at the effective date of this amendment. Now that's different. I mean, that's something else, but the crux of this lies under, and I gave you all a copy of the zoning ordinance here, and our ability only goes so far as to apply the ordinance and read the plain language of the ordinance. It's not for us to read anything additional into what the words say. And under Article 2871, Section A, it clearly states that in any district, except as may be otherwise provided in a performance district, or Article 2884, non-conforming uses of land, if any building or structure is constructed or enlarged, or if any use of land is established or changed, off-street parking and loading spaces shall be provided for the entire use or combination of uses in accordance with the requirements established by this ordinance. And it's pretty plain there where it says, if any structure is constructed or enlarged, it initiates or puts this requirement into effect. And that's the way it's been applied for as long as I've been in this office. So.
Sorry, you're looking at 28.8.
2871A. And there should be a copy right in front of you there, Andrew.
Yeah, okay.
In your view, is it that Mr. Walker is misreading that provision, or that provision is in conflict with the Bartlett decision?
The Bartlett decision only set up the procedure. So all the Bartlett decision said is you don't need to file an administrative appeal.
Okay.
So when you apply for a variance, you can ask the zoning board to take a look at it and see if it's even required. You couldn't do that prior to Bartlett. You would have said, we're not going to take that up because you didn't apply for a timely administrative appeal. That's no longer necessary since Bartlett. So that only sets the procedure. My argument is based on the express language of the ordinance, the Constitution. Every ordinance has non-conforming protections because it's constitutionally required, because you can't make laws retroactive, right? So things that are in place get to stay in place. It's also based on my reading of some of the cases reported by the Supreme Court, in particular Devarro 12 Atlantic LLC versus the town of Hampton, which is a decision that talked about non-conforming uses and their constitutional nature and why they deserve to be protected, and so on and so forth. So I read this, and if you just read the section that was cited, it overlooks what 2884 talks about, which is a more specific provision directly related to nonconformities. And it lists out a number of criteria, right? And we satisfy all of those. I don't think there's any dispute to that. And if the officer's interpretation is that the first section of that supersedes this, because they're apparently in conflict, I would respectfully disagree.
So let's just assume, obviously we haven't deliberated, but let's just assume hypothetically we grant these variances. It's still important to you to make the decision. No, because the variance, you have somewhat less protection than if you didn't need the variance at all, right?
In this case, I think that's a good point. On some cases, that would be true. Here, to us, it doesn't really matter. I'm trying to do my job for my client the best way that I can.
Sure.
And thought I would be deficient if I didn't at least raise it. But at the end of the day, it doesn't matter to us. If you'd prefer not to cast an opinion on this, I have no objection to putting this on the side burner and going to the variances and see how they go. And if they go well, that issue is moot.
Because I have to be honest, that, you know, I'm a little bit lost with all of the, to render a good decision on that first question, I'd honestly have to read I'd have to think about it quite a bit more.
You would also have the option of counsel from the city solicitor too, if you so
Yeah,
wished.
because that seems like I know that this has come up in different forms, but personally, I'm not comfortable setting precedent on something like this when it seems pretty complicated. I mean, if it comes to a vote, I'd probably abstain on that first issue right now.
Well, it's going
I'm
to
not
come to a
in
vote.
Yeah, I'm just not in a position to make a decision on that. If we can, so.
Let
I
me
guess
let me
that's-
ask you a question, though,
Yeah.
about it. It seems to me, if I'm hearing this correctly, and if I'm not, set me straight, that the language that Craig quoted concerning the expansion of a non-conforming use was pretty clear. Is it not clear to you?
We're talking about 2871A.
I don't remember the number of it.
Well, the
right?
non-conforming
He
is
just read to me
2884, section A1, and then the access, circulation, and loading requirements, 2871A, so.
Right, but what triggers all of that discussion?
An expansion, and that's, you know, again, going back to state RSA and such, and they talk there where there's really no material substantial change in the alteration of the building and such like that. So that's where that protection comes from. That protects you from when the ordinance perhaps changes, and let's say this use would no longer be permitted in this zoning district, we can't go back and shut them down or require them to get a variance. That non-conforming use can continue forever so long as it essentially remains unchanged. What this says is if you change or enlarge, then you have to bring it into compliance with the parking standards. So it doesn't retroactively apply anything else. So.
It doesn't seem to me that by accepting that you abandon the protection of the non-conforming use. It just means if they change it, they abandon the protection. And if it's not changed, and it doesn't say in there that the change has to be out of compliance with the ordinance, it just says an expansion.
Because that's his argument, that the change is not out of compliance.
If I heard him correctly. Did I hear you correctly on that?
Yeah, the changes, the two buildings, they comply with the zoning ordinance.
So that's adding a wrinkle that I don't hear in what Craig is reading, and I don't think we're invading their protection, their grandfathered protection, as long as there isn't some reason to think that that's unconstitutional. We're not in a position to argue that one way or the other.
Right, I don't know about the constitutional argument there.
Well, not too many constitutional questions get decided at the zoning board, although I'm sure,
or if they do, they get decided
I'm
badly.
sure we could get some robes and a gavel and do it upright.
Right.
Up to now, it hasn't happened.
Thank God.
Okay. So
Okay, that clarifies it a little bit.
I think we need to address question one.
I'm sorry, I had a question.
Okay, yeah.
So I want to better understand the Bartlett question you raised. Is your concern, Andrew gave you a scenario of what happens if these are all approved, it kind of goes away. But in the event that they're denied, is your concern that if he didn't raise the Bartlett question here, you wouldn't then be able to go to appeal this and say the zoning officer made a mistake?
As you know, on appeal, if I don't put it on the record here, I waive it.
So do you need you're looking for a finding on that, so in the...
No, I mean, if you went and voted on the variances first and we prevailed, I would withdraw the other claim, make it simple. I don't particularly care how the relief is granted. In this particular case, it doesn't matter to me. So if you wanted to defer on question one and take it up last and deal with the two variances, that works perfectly fine for me. If you see fit to grant the variances, I'll just withdraw the request on the nonconformity.
Well, I'm going to do it the other way around because we don't want to waste time. If we agree with you on question 1, the rest of it is not we don't need to spend any time.
It's your prerogative, Mr. Chair. However you see fit is fine with me.
So, gentlemen, I think what we should do is address first question 1. Well, there's 2 questions. One. Yeah.
So if we go on with Craig, they still get to, would get their variances, correct?
Yeah, it's not dissimilar from other requests we've had in the
All right.
past where people have said, we think the
I just want to make
code
sure.
enforcement officer made a mistake. What do you think?
Okay, thank you.
How the Bartlett thing figures into it, I'm going to have to go back to law school, which I never went to begin with, to get that one sorted out, but it doesn't matter, I don't think, to us.
Well, I'm going to somewhat contradict what I said before, but I'm thinking about it, and I think Chris kind of clarified it for me, and I never have enough to make, I think, a perfect decision, but I think I have enough to make a decision now. So I'm going to move to uphold Craig's decision.
Is there a second?
Need a variance.
I'll second that.
Is there discussion on the motion? All in favor?
Aye.
Anyone opposed? I think the vote is unanimous on the board to uphold the Code Enforcement Administrator's interpretation of the ordinance, which means that we move on to the questions raised by the variance, which was to allow the parking, I think it was parking and a landscaping arrangement to stay as they are.
That's correct.
You weren't eliminating any parking?
Actually, I think you're adding one, aren't you?
They're adding the handicap parking, correct?
We're adding 2 compact spaces on the side.
Not in the front, though.
And you made the case in your submission of how you believe you comply with the 5 criteria. Did you want to hit any highlights on that?
No, I think it's pretty succinct, and it basically relates to their long-term existence without any difficulty. They've become kind of the spirit of the community and the fabric of that particular neighborhood, which goes to the 2 prongs regarding, spirit and intent. As far as the valuation issue, I spoke to that. It's not changing at all, so the valuation should be the same in the pre-build and the post-build condition. So I'll rest on what I've submitted.
Thank you very much. If you 2 would step down, we'll see if there's
I actually
anything.
had a question.
Oh, excellent.
Can you go back to the street view?
So are you asking for any variances on signage?
No.
No.
So it looks like there's a non-conforming sign.
Those were created by previous variances, so the variance continues with the property.
Can you explain that? When?
I don't have the actual dates on those cases, but yeah, the large golf sign in the back here, yeah, I believe size-wise and height-wise, it is non-compliant. But again, that came before the board many moons ago, and yeah, it was prior to the current ordinance. It was before 2001, maybe even been back in the mid-'80s or early '80s. And the variance was granted to allow that signage. I assume maybe at that time the trees weren't quite so tall along the highway, and it was helpful to have it visible from the highway. But again, unless they remove that structure, if they remove the structure, then the variance goes away. But so long as they're only doing a face change and they're maintaining the structure, the variance continues to run with the land.
And what about the additional signage on the closest to the street? There seems to be a sign that hangs off the bottom of the, underneath the pricing.
Again, that is, well, that has
Right.
that goes away. That is not something that's permitted, but everything else here has been properly permitted in the past, and even though it's non-conforming, as long as they don't change it, it can continue.
Okay, no, so the non-permitted sign there that's up at the bottom there, that they're not,
We chase those down all over the place. They're
I remember it was a while ago, there was another gas station applicant who claimed that they themselves don't like those signs, and
Yeah,
the vendors come and put them up.
Aranosian, I believe it was, yeah.
you all know why it's there?
I do not. I will bring it to the owner's attention. If it's not supposed to be there, we'll make sure that it's not.
Yeah, I don't think it's
but
there
that's an old, that's an
today.
old picture.
This is an older
Yeah,
picture.
I-
Look at the
This
gas,
is,
you can tell by the gas
so-
prices.
And
AAA van.
I'm pleased to say.
Both
They don't look
the,
like that now.
Both the gas station tenant and the convenience store tenant is changing too. It's no longer going to be Golf and Cumberland Farms. It's Apple Green and 7-Eleven.
Any other questions from the board on the variance
Just
request?
one more question, just one more question. I think I get the first variance one you're asking for. Obviously, you can't move where the parking lot's gonna be, but as far as the landscaping, is the purpose of that ordinance really only relevant if it's in the side or the back?
Right. So here's the property line here. So when this was developed, they did not have that requirement in there.
Oh, so it'd be,
Right where the yellow line is.
it would require a
Put
lot of
landscaping under the
construction
canopy.
to-
Right,
Yeah.
into the canopy, right?
Yeah, I see.
Very good, thank you very much.
Thank you all.
Is there anyone who wishes to be heard in favor of this appeal? Is there anyone who wishes to be heard in opposition to it? Craig, any more comments from Code?
I think I've said enough for now.
Okay. With that, we'll close the public testimony portion of the hearing. We have already dealt with item 1 concerning the request to overturn the code enforcement administrator, so we're only dealing with items 1, 2 under the variances. We have heard testimony that this is a pre-existing condition that has obtained for quite a long time. It is a non-conforming use as opposed to a permitted use by variance, and that the situation will actually be improved by the changes they wish to make. The changes they're making to the building are rather modest. Discussion?
I think it's a reasonable use of the property. Make it, we approve it.
You move approval?
Yeah.
Of both, 1 and 2.
Yes, sir.
Is there a second?
I'll second.
Any discussion on the motion?
I only add that, I think that they did emphasize the benefit to handicapped accessibility in the changes, which I think is appropriate. And then, I'd hope the minutes would reflect the fact that they're going to address any inappropriate signage that's associated with the space.
Very good.
It seems that because this is a reasonable use, the 2 variants we're granting would be either impossible or an extraordinary burden for them to try to comply, so we inherently really would need to grant those variances.
All in favor?
Aye.
Anyone opposed? The vote is unanimous. The variances are granted. That moves us on to our next case this evening, case 4217, MJSB Associates. The applicant wishes to modify previously approved parking for a general office use and requests a variance to the table of off-street parking to provide 13 parking spaces, 6 on-site and 7 off-site on an adjacent easement where 19 spaces are required for property located at 8 Center Street in a CVP Civic Performance District. Gentlemen, swear to tell the truth.
Stuff missing.
Yes.
Thank you very much. Would you identify yourselves for the record as you testify, please?
Mr. Chairman, members of the board, I'm John Arnold. I'm an attorney at Hinckley Allen. This is Bob Bowers, who is principal of the applicant. Just briefly, I'd like to get you oriented with the plan because there's a couple of unique aspects of this property. You all have a copy of it in your packets, and I brought a full size that I can put up if you like, but I figured it'd probably be easier to follow along with what you have in front of you. The property we're here for tonight is 8 Center Street, and you can see on your plan that Center Street is right across the bottom. The lot's very small, 0.19 acres, and the lot lines aren't where you'd expect them to be when you're looking at the map and when you're looking at the plan, so it's important to take a close look at the plan if you have it in front of you. The front lot line, they're the dotted lines that show the lot line. So the front lot line for the property actually cuts across right in front of the front steps to the building. You can see it going across the brick walkway. It's not down kind of at the edge of the street where you'd expect it to be. Most of that brick walkway is actually within the city's property, a very wide right-of-way right there. And then if you follow that over to the corner of the property, you'll see that the lot line on the right, or the east side of the property, actually runs up and kind of cuts through the middle of the parking lot. And so on the plan, you can see that the spaces on the left bank of the parking lot closest to the building are actually on the site, but the bank of parking spaces on the right side are actually off-site. Those are actually part of the Stuart Nelson Plaza property. And there's a permanent easement that's in place for the encroachment of that parking lot onto the Stuart Nelson property, but I just wanted to point out where those lot lines are because it's very unusual and not what you'd expect when you're looking at what the property is. So we're here tonight because we're looking for approval essentially of existing conditions. The plan you have in front of you is existing conditions with the exception of the designation of a handicap parking spot, which we've added to the plan. We're not proposing any other changes to the parking lot. The reason why we're here tonight is because there was a prior approval granted in 1981 for this parking situation. It was a special exception granted by the ZBA to allow 6 on-site parking spaces and 18 off-site parking spaces. Now, the on-site parking spaces are in the lot that you see on the plan in front of you right now. And in 1981, there were the off-site parking spaces that are on the easement that I mentioned a minute ago in the same parking lot, but there were also 11 more spaces that were being leased from the Stuart Nelson Plaza that were completely off-site, not part of this parking lot, in the main parking lot on Stuart Nelson. The problem is that the lease expired 15 years ago. Nobody really paid any attention to the expiration of the lease or even the existence of the lease at the time because in reality nobody used those parking spaces. Since 1981, since this applicant has owned the property, they've operated and functioned using the existing parking lot with those 13 spaces that you see on your plan. So when the lease expired 15 years ago, it never became an issue because they weren't using those spaces and nobody really paid much attention to it. The issue came to light recently, realized that the property was out of compliance with the code because the 1981 approval contemplated a parking lease which no longer exists. And so we're here tonight to essentially ask for a variance to allow the parking situation as it has existed and has been used since 1981 with the elimination of that parking lease that was in place previously. So with that background and explanation of the plan, Bob will speak to you briefly kind of about the use of the building and the use of the parking over the years, and then I'll just touch briefly on some of the justification for the variance.
Good evening. I'm Bob Bowers. In 1981, 3 of us, we had an office in Concord in Stuart Nelson Plaza. Our business was expanding. We needed more room. 3 of us formed MJSB and bought an apartment building at 8 Center Street. We converted it into office spaces with the purpose of moving our offices into there and accommodating expansion. That consisted of 4 separately accessible units. So when we first went into there, our business had 1 unit. The other 3 were empty. We slowly expanded over time to utilize 3 of those units. At some point in the 80s, we leased the 4th unit out to Capital Valley Counseling Center, which is there today. Over time, we then began to get smaller. We went from 1 up to 3, back down to 1 at the same time. The counseling service got larger. I don't know what that says about society, but they went from 1 unit to 3 units. I retired in 2000. My 2 partners that own this building with me are now both retired. One of them has moved out of state. None of us live in Concord. We didn't want to continue to own this building, and so I turned my attention to trying to sell the property. As we looked at trying to sell the property, it dawned on us, and I admit it should have dawned much earlier perhaps, that we were not in compliance with our original proposal. For all those years, 35 years, we had never had any need. The nature of the business was that that parking lot was rarely, if ever, actually filled, even with just the 13. That remains true. Today, it probably fills up more, but I've come down randomly and found many spaces still available. The problem is that the lease ran out. I turned to the then owners of Stuart Nelson Plaza to see if I could continue to lease some spaces. They said no. I turned to a property up the street. It was Hall Morris at the time. They've now sold. I asked them if they had extra spaces that we could lease. They said no. There was a church across the street, the Episcopal Church, I think it was, that I didn't talk with them directly, but I had talked with someone who had tried to lease space and found that I could not lease space. I had some conversations with the city, nothing formal, but the best I could do was I think, month-to-month rental at the other end of town, which was in South Main Street. We looked around. I asked some brokers to look around. There was nothing that we could find that was available to lease. We then had a problem. We could not sell the property. We were trying to sell the property without coming into compliance. We couldn't come into compliance, and we then retained the Inkley firm to prepare a request that we be allowed to continue the use that we'd had for 35 years in its current form. They have recommended, and we have agreed, that we will label one of those spots as handicap accessible, and that is the proposal.
And so, just to wrap up, our justification is on the written application. I'm not going to go through it all here unless you have specific questions, but I would just like to point out that in kind of turning back to the plan, this is an undersized lot, 0.19 acres. You can see from looking at the plan that the building takes up basically the whole site. There's no way to put any more parking on this site anywhere. And as a practical matter, the site's operated just fine with the existing parking lot since 1981. Even though there were an additional 11 spaces that were leased back in '81 on the Stuart Nelson Plaza, as a practical matter, those were never used. And so the expiration of that lease, we don't think has an impact on the ability of the property to continue in its current state. And as I said, we're not proposing any changes to the existing condition. The only change is to designate one of the existing spots as a handicap spot. Now, in full disclosure, it's being marked as a handicap spot, but it doesn't meet the required dimensions for a handicap spot. There's not the room in the parking lot to be able to do that, but we feel like this proposal gets us as close as we can and improves conditions the most as we can to address that. So we do believe that the parking, as it's laid out now, is adequate and reasonable, and that's why we're asking for the variance.
Questions from the board?
Can you explain to me better the fact that you're marking something as a handicap spot, but it doesn't meet the criteria? How far off are you? What would you need to do to make it a compliant handicap spot?
So essentially, to make it a compliant handicap spot, it would need to be a little bit wider and a little bit longer than it is, and it would need a wider aisle next to it for the loading and unloading for the accessibility. And so to do that, you'd end up eliminating a parking space in the lot. And so we felt that by reserving a space as handicapped operably, it'll probably work as a practical matter, but it's not strictly conforming. And if you look at the plan, we selected the parking space at the end of the parking lot on the left because that was the space that provided the most space around it. You can see to the right, it's at the end of the lot, so there's a kind of an island area. It's not an island, it's just, a marked area at the end of the parking lot, which gives a little bit of an aisle on the right. And on the left side, there's a walkway that goes into the back stairway to the building. So we felt as a practical matter, we were providing basically as much space as we could in the parking lot for accessibility and for those added dimensions without, again, being able to strictly comply without kind of doing a full reconfiguration and eliminating parking spaces.
Does it just need to be wider to be conforming?
Well, standard handicap parking space, I believe, is 8 feet wide by 19 feet long with a 5-foot aisle, loading aisle onto the side of it. So I'm not sure what the dimensions of this current one is. And there's other designs that actually decrease the size of the parking lot, the parking space a little, make it a little narrower, make the aisle next to it larger. It still occupies the same amount of space, but prevents people from parking improperly.
So they're not required to have, they're not asking for a variance for to not have a compliant handicap spot, so it's not required under the code?
Right, again, they aren't changing the use in this case. So, it's maintaining the same use, so that doesn't, and they aren't enlarging the building. So that doesn't trigger the requirement to bring the parking completely into compliance. They're just want to reduce the number of parking spaces that they originally.
So the lack of a handicap spot is a pre-existing that's not being changed, so I see.
So on ours, we didn't need to address that. We were trying to do the best to address it while trying to avoid eliminating a lot of parking spaces or reconfiguring the whole parking lot as a compromise.
Other questions? Thank you, gentlemen.
Thank you.
Is there anyone who'd like to be heard in favor of this appeal? Is there anyone who'd like to be heard in opposition to it? Any comments from code enforcement?
Nothing more to add at this point.
All right. That will close the public testimony portion of the hearing. We've heard testimony that the appellant had previously, early 80s, been granted a variance.
81, I believe.
Which at that time allowed them to go off-site with some of their parking. I think that's now done by planning board, is it
Well,
not?
again, at that point in time, I believe it was a special exception to permit off-site parking.
Okay.
The use was a permitted use in the district. They just needed to provide parking.
Weird.
Yes, correct. It would be a conditional use permit by planning board. Yeah.
We heard testimony that they did not use those spaces. The lease lapsed several years ago and no one noticed because it wasn't being used. And they have requested that they be forgiven the use of requirement for those spaces and allowed to retain the parking that they have otherwise adjacent to the building. Discussion.
I don't know why tonight's my handicap parking spot night, but I'm going to support it, but I'm just a little concerned that the property owner is going to identify it as a handicap space when in fact it's not really. I mean, I'm glad to see that they're dedicating it as a handicap space, but I'm just a little worried that if it's officially marked as a handicap space and it's not, just gives me some unease.
Yeah, well, there's another problem there with that, but I'm not sure it's part of our issue tonight, which is looking at this footprint. If I'm reading this plan properly, that handicap parking space is about as far from a place where you can get into the building without going up steps as you can get.
Yeah, I can see why they may have done it because it's at the end. If it was a van or something like that, there might be a little more space. But again, it's not.
But since it's not required, it's not.
I see there's a grade there too, which I didn't see before.
Yeah, there is a grade uphill, and I think what you'd have to do, if I don't misread it, is you'd have to go all the way up the driveway and back around in the front off Center Street.
I think there's a back door here too, but that again requires steps and. Yes,
Right.
so
Not everybody who uses a handicap parking space has to have a wheelchair, but.
Yeah, and so I'm not sure who it is in the world that deems something an appropriate handicap spot, if it's us or if there's.
That's a building code thing.
Yeah, okay.
Any other discussion?
I agree with Jim, but on the handicap issue, but I also think it's not within our purview. They probably shouldn't even mention it, because I wouldn't have thought of it otherwise. But I think as far as the variance that they're asking for, I don't know what else they could possibly do other than taking down part of the building or digging, underground or something. They're not going to be able to come up with more spots, so
Making the best of what they have.
yeah, so I move to approve the variance. They have no other alternative whatsoever.
Is there a second?
I'll second it.
Is there any further discussion on the motion? All those in favor?
Aye.
Anyone opposed? The variance is granted. The vote is unanimous. The next case is 4317. It's 117 Manchester Street, LLC. The applicant requests a variance to Article 2872E, the table of off-street parking, to provide 122 parking spaces where 138 spaces are required for multifamily residential use and mixed commercial uses, and maintain previously granted parking relief for property at 117 Manchester Street in a CH Highway Commercial District. Gentlemen, do you swear to tell the truth and nothing but the truth?
I do.
Thank you. If you would identify yourselves for the record as you testify, I would be
Yes.
grateful.
My name is Philip Hastings. I'm an attorney with Cleveland Waters and Bass. I represent 117 Manchester Street, LLC. I have with me today Robert Sullivan, the principal of the property owner. I have a few handouts, and I believe Craig is
Good, thank you.
We were here, if you will recall, 2 months ago, I believe in September. We obtained a modification for a variance to allow 35 one-bedroom units in the building on the site that's located at the corner of Old Suncook Road. Takes a 90-degree angle, so we proposed 35 one-bedroom units in that back building. This board graciously granted that variance.
There's one for, you know.
We're playing with paper over here.
Hold on a second.
Excuse me.
You should have an existing conditions plan as well as a 3-sheet set of basically landscaping and parking sheets.
All right, we have a photograph of the building, several photographs of the building, a site plan, a parking summary, which is a table, and this supplements what was in your original application.
Yes, that's correct.
So do we have everything?
I believe that's everything.
Okay. Did you guys need another one of these? Okay. Please proceed. Sorry to...
Thank you. And I hope this makes Mr. Monahan happy because we are providing sufficient handicap spaces. So at the time we got the variance application, a full review of the site had not been done from a site plan perspective. There's, as you can see on the table, the parking summary that I submitted, there's currently 157 parking spaces on the site. We felt, given the, in our ignorance, we felt, given the change of use, that there would be more than enough spots to accommodate the use, so we didn't ask for a variance back in September. As we refined the plans for the site in connection with site plan approval, working with Craig and the city planning staff, it was discovered that while there's a sufficient number of parking spaces on the site for the proposed use, in order to comply with the various landscaping requirements, it would require the loss of a number of spaces. Specifically, the landscaping requirements we were trying to come in compliance with are the interior, the percentage of interior parking, the percentage of landscaped area within the perimeter of a parking field, which have to be at least 5%, and Craig, correct me if I'm wrong on this, 5% of the lot must be dedicated to landscaped areas within the perimeter of the parking lot. So we've tried to provide enough parking as is sufficient to meet the needs of the proposed use of the site, while also providing complying with the landscaping requirements. We've done this in a couple of ways. One is by reducing the permitted number of one-bedroom units in that back building. We have a variance for 35. We've reduced that to 31. That helps create some, reduce the parking need. We've also, to meet the landscaping requirements, we've eliminated or reconfigured the parking at the building entrances. If you take a look at the existing conditions plan and the street view photographs from Google Maps, You can see on both ends of the building, there are several parking spots. I believe somewhere between 12 and 15 parking spots are being eliminated there to increase parking. To increase landscaping. So as you see on the landscaping sheets, there'll be a number of new plantings, new walkways, increasing the pervious surfaces, and in general to create a more aesthetically pleasing entrance to what will now be residential uses as opposed to commercial uses. In addition, within the parking lots themselves, we've added a number of landscaped islands. Those are shown on this sheet with the green. You can see them as the hatched, cross-hatched areas. Those will be landscaped in accordance with the requirements.
Believe it or not, we think we don't have all the paper.
Second page, coverage plan, I have everything.
You do?
Yeah, that's please.
So you need,
Okay, it's this guy with the yellow.
It's labeled LA-1.0.
Got it, yep.
So you'll see there's several hatched areas. Those are all proposed to be landscaped islands that do not presently exist. Those eat up additional parking spaces. Another change to the parking layout, city planning staff had a concern about the flow of traffic in the interior of the parking lot in front of Building A. You can see currently on that plan, there's a center aisle and parking on both sides, so traffic pulls in and out of a single center aisle. To increase the traffic flow, you now have a more circular pattern around that parking field, which is better from a safety standpoint, but again, it drives a loss of parking spots. The third issue is with respect to the handicap spaces, there are currently 3 handicap spaces on this site. The code requires 5, so we have added handicap spaces to comply with that specific requirement. You see those noted on the plan, and in order to comply with sufficient aisle and width and dimensional requirements for handicap spaces, we've had to lose additional parking spaces to accommodate that. In total, we're proposing to construct 122 spaces, where 138 otherwise would be required by the ordinance.
how do you derive the 138? It's 2 per unit?
The 138 is 2.
135.
It actually came out to be 138.
With the handicap?
With the handicap, yes. It's the requirement for apartment units is 2 spaces per unit. And what's interesting about that is under the ordinances, there's no distinction about the size of the unit. So if we were proposing 2 or 3 bedroom units, we would we'd have the same requirement as we're proposing now. We think 1 bedroom units will require fewer parking spaces than is required. And then for the commercial use, it's 1 space for 250 square feet of commercial space. So that's added in, right? So the requirement is 94 spaces for the residential use and 44 for the commercial space. We think the proposal that we have before you creates a much better project for a number of reasons. First, as we just mentioned, the number of parking spaces is more than adequate. These are 1-bedroom units. The demand will be less than what's in the 2 or 3 bedroom unit apartments. The ordinance makes no distinction between the size of the apartments for calculating the parking requirement. It's something of an anomaly in the ordinance. Plus, because of the nature of the use of the first floor of the building B, the commercial space along the easterly side, there will be limited overlap in the actual parking uses between the commercial and the residential spots. The residential use is largely after hours. The business use is during the daytime. The ordinance contemplates a shared parking arrangement in these situations by conditional use permit, but that option is not available to us in this case because of the various site constraints that we have within the existing site. The other factor here is we're eliminating some spots along the building entrances. Those could be left as spaces under a conditional use permit as dedicated for future use if needed. But if we were to do that, we would then have to remove some of the landscaping, and we'd be asking for a variance and waivers from the planning board for the landscaping requirements. So that's not a viable option for us either. Lastly, we chose to prioritize the landscaping requirements over the parking requirements. By doing so, the presentation of the building is greatly enhanced. We've substantially increased the amount of permeable area and green space in and around the parking fields. And this seems more in keeping with the broader objectives of the zoning ordinance read as a whole. We outlined in our application how this satisfies the requirements for a variance. I'm happy to review any of those with you. Mr. Sullivan's here to talk about the parking demand and the particular uses based on his experience in these types of projects before.
So if I correctly understand the situation, you find yourself in a conundrum or a dilemma of sorts. Whatever you do to comply with one aspect of the ordinance creates a violation of some other aspect of the ordinance.
That's exactly correct.
So you decided to pick the least obnoxious solution to the problem, which was to add to the landscaped area and give up parking that you don't feel you need.
Yeah, that's a fair statement. I think in this day and age, we're finding that the zoning ordinance in general requires much more than is actually needed in a lot of cases. Here in particular, because they're one-bedroom units, we think the requirement overstates the actual need. So in weighing the need for adequate parking with the desire and public interest in providing more landscaping rather than less landscaping, we felt that was the best alternative.
So how many one-bedroom units are there?
There'll be a total of 47 on the site.
And are they all the same square footage?
Roughly 560 square feet, plus or minus. There's an existing 16 units in Building B right now, and out of those 16 units, I would say, because they're one bedrooms and we're under the requirement of basically 2 per unit, maybe 20 cars out of that. So instead of 32, we're probably using 20 parking spots. So we know our numbers up there over the last year and a half that we've owned the building, that the average is about 20 cars for 16 units.
You mean at any given time, including like if someone had a visitor or whatnot?
Any given time, right. Not everybody's home at the same time, so basically they're using those particular 16 one-bedrooms park on the far end here, in this area here, and basically these 5 or 6 spots on each side.
Do you set aside certain parking places for the residential use and others for the commercial use? Or is
Yes,
just
the commercial is all, the whole front. Residential, they're allowed to use it on the weekends. They really use the backside because it's an easier access for them to get in, just closer points. If you park out here, you still have to walk all the way down and in. And it's just easier, then they don't have to worry about getting up in the morning, moving their car.
But if for whatever reason, a lot of people have visitors like on one day, they could use that as overflow.
Correct, yeah, they have, and they do on a daily basis. The overflow is really in these two spots.
Other questions from the board? Nick, any questions? Nope. Jim?
Nope. I'm good, thank you.
Andrew? Thank you, gentlemen.
Thank you very much.
Very much appreciated.
Is there anyone here who wishes to be heard in favor of this appeal? Is there anyone here who wishes to oppose it? Any comments from code enforcement?
Nothing to add. They've pretty much addressed all the concerns we had, so.
Very good. With that, we'll close the public testimony portion of the hearing. We have a request to provide or to grant a variance for the number of parking spaces in favor of increasing compliance with the requirement for landscaping to what the ordinance demands. We heard testimony that there is no other parking available on or near the site, and that their experience with the property is that it doesn't need it. Discussion?
Somebody move?
Not yet.
I think it's a reasonable use. I mean, I think it's gonna, the building's gonna feel a lot more like a residential building and the landscape up to compliance. I make a motion to approve.
Is there a second?
I'll second.
Moved and seconded to grant the variance. Is there any other discussion on the motion?
I think they made a lot of good points with the fact that they're all one bedrooms and just it's a relatively large complex, so just the law of averages is not everyone's going to be using all the spaces all the time, so it seems highly unlikely there ever be a parking issue. And they really did a good job balancing the need for the landscape and still coming pretty close to the number of spots.
All in favor?
Aye.
Anyone opposed? The vote is unanimous. The variance is granted. That brings us to case 4417, Pennacook Assisted Living Facility, DBA John H. Whitaker Place. The applicant wishes to expand an existing assisted living facility from 54 units to 72 units and requests a variance to the article concerning multifamily building dimensions and separation to permit a building with a 350-foot plus or minus horizontal dimension, where a maximum horizontal dimension of 160 feet is permitted for a property located at 30 Borough Road in an RM residential medium-density district. A portion of the lot is in a CG general commercial district. Wouldn't hurt to have a couple of wall washers over there, would it?
No. Used to have an easel kicking around somewhere, but, oh, it's in the back of the room now.
Right, I couldn't fold this up.
Yeah, that's fine.
Are these maps also in our packets? Because I didn't see anything online with maps.
These colored ones are not, no.
But the same information is here?
Yes.
Okay. Gentlemen, you swear to tell the truth and nothing but the truth?
Yes.
I do.
Thank you. Would you please identify yourselves for the record as you testify?
Hi, I'm Dan Luker from Purdy Flaherty, here on behalf of Pennacook Assisted Living Facility, better known as John H. Whitaker Place. And with me is Mark McLeod at HL Turner. Hopefully he'll do most of the talking. We're here seeking a dimensional variance.
Oh, and in the audience, we have Alan Moses, who's the administrator of John H. Whitaker Place.
All right, so as you can see in the application, basically what we're requesting variance to add a 75, increase the length of this building by 75 feet. It's already does not conform with the ordinance for building length.
which limits it at 160 feet. The existing building is 275 when you measure across the arms there. In this instance, the Whitaker Place is proposing to, this addition, it's an additional 18 units on 2 stories because they basically have maximized the space of the facility that they have now in order to provide additional services to residents. This is really the only option they have to expand on this site, other than if they were to build a standalone structure. In this instance, they are on a large site, a little over 8 acres. This addition, even with relocating the driveway, still maintains a pretty sizable buffer on that west side. We're not encroaching within any of the building setbacks or buffers or anything of that sort. It's really just a request to make it more non-conforming, essentially, with this addition.
Do you have a variance already?
There was a special, I think it was, a variance was granted back in, a special exception or variance, I forget, 1999, when it first went in. And at that time, it was classified as a residential social service center. That was under the old ordinance. And then they enacted the new ordinance, and for some reason, they didn't make this area more institutional, and they left it as is, and now it's called, it now qualifies as an assisted living facility. So, short answer is, yes, I think it was a variance, but I'm not sure.
Actually, it was a special exception and to permit the residential social service center at this location. Under the current ordinance, as, again, assisted living facilities was not a classification under the prior ordinance. We have it now, and it is a permitted use in this district.
When did the dimensional restriction happen? Because they clearly were in excess of it already.
That came into play in 2001 when we adopted the current ordinance.
So prior to that, there was no
Not that I'm
horizontal maximum.
I'd have to pull out the old ordinance, but no, I don't believe there was, because there was no reference of a variance for dimensional.
So they're a pre-existing non-conforming use?
Yes.
It's fun to say that.
And I believe we said that in our application. I won't belabor the application. I just want to run through. I mean, the hardship standard is usually pretty squirrely, and it's hard to get things into it, but this one fits rather nicely. There are special circumstances here. It's a legal use, but it's a sort of a special use, if you will, for assisted living folks. It's distinguishable from the other properties in the area in that it's its own sort of campus. It's a large parcel. I believe there's power lines on one side. There's a multifamily. Is that to the north? I'm not sure what that is.
That's the east.
North, okay. And 30 Pines is off to one side. There's a couple, but basically it's a campus that has its own infrastructure, its own, as we said, the cruciform shape there. And with the addition here, we're not really impacting anybody. It's all well buffered. I'm not sure that people will be aware of it unless they're going to be driving to the place. But it's sort of a unique property. It's a campus setting. In our view, there's no fair and substantial relationship between the purpose of the ordinance, which is, or the dimensional restriction here, I guess, doesn't want big massing structures on the street and stuff. Here, we don't really have that concern. And more importantly, we have sort of a special circumstance. We're adding 18 units on one leg of the cross, if you will, but all those folks have limited mobility, and the alternative would be to build a separate building. We really need interior access so they can get down to the center of the cross where you have dining and community affairs. So it's really important that we try to connect these buildings for this particular use. So we don't see any real relationship between the dimensional limitation, if you will, and the purpose of the ordinance. It also won't impair in any way the fire or safety access. There's obviously access all the way around the loop, but in particular, you can get on any side of this building fairly easily. So to force the applicant to build a separate building just for the sake of building a separate building, in our view, would kind of violate the substantial justice standard. We think we readily meet the other three standards. And it's certainly not contrary to the spirit of the ordinance, which is to promote safe and reasonable development. We're doing that, again, within our own campus. It's not contrary to the public interest. We're clearly serving a public need. We've got an aging population in the Concord community, and this is better than a nursing home. Lastly, we don't think there's possibly anybody could argue with a straight face that there's a diminution of value of surrounding properties. They're well away from the property lines. They're well buffered, and in large part, there's either power lines or some commercial property, and even the nearby residential multi-uses, again, I submit won't be aware of it, and so I think it's sort of the best practical solution to a clear need, and we think it meets all the variance standards.
Very good. Are there questions from the board?
Is this 4 stories?
2.
2. Okay. Was the building originally built for this purpose?
Yes.
And do you know when?
1998, 1999.
Craig, if they were to move this whole addition 4 feet to the west and pave the alley in between, would they eliminate the need for this variance?
No, there needs to be a 40-foot separation between the
40
buildings.
foot?
Yes.
Other questions from the board? Thank you, gentlemen.
Thank you.
Is there anyone who wishes to be heard in favor or in opposition to this appeal? Any comments from members?
Not necessarily a specific question.
With that, we'll close the public testimony portion of the hearing. We have a request to add to an existing non-conforming building, which has been overtaken by a change in the zoning ordinance, to expand its current use, which is as an assisted living center. We heard testimony that the function of the building would be injured, or the functionality of the building would be injured by complying with the ordinance, and we need to separate it in addition 40 feet from the existing building, creating another building. Discussion.
I've been to this campus, and it's a nice. They've done a nice job with it, and there's a demand for this apparently. So,
can we put the screen back down and take a look at the at the location?
Have you ever been to the campus?
I'm sure I have, but I don't have a picture of it in my mind. There we go.
This is the building, and that's the parking, sorry. The best thing with Google Maps is that I don't have to remember all these things.
Yeah. Folding your computer usually doesn't work out all that well.
Yeah.
So there we are.
There's 30 Pines is there, Borough Road, the intersection of Manor and Village.
Can you do a street view for us along the perimeter of this guy? Or failing that, some other entertaining place in town?
I'm not sure the street view is, it's not coming in. Maybe they haven't driven down that street yet.
Interesting, okay. Well, if it's not there.
Yeah, it's not showing up yet, so.
Well, that's 30 Pines.
Yeah, so it's right back in there.
That way.
It's a good spot for it. It's pretty.
Well, let's see.
Take a right.
Get on Borough Road.
Oh, wait.
Get back and right.
It's convenient.
So that,
That's Borough Road, you gotta take a right.
Yeah, okay. It's not coming up.
The bike?
that's you and the bike, yeah.
Yep.
So, now Borough Road then is at the,
Yeah, this is Borough Road down here along the bottom. Yeah.
so am I correct that you really can't see it very well from the road?
Oh, no, you
It's
can.
pretty well screened, but there's, a lot of mature trees around it. Yeah. Various angles, you can look into the campus, but.
If you're driving down Borough Road and you're looking for it, you'll see it, but it's got a fireplace on one end of the building when you first drive in.
Okay. Thank you, Craig.
Yeah, nice building.
Discussion.
I move to approve.
Is there a second?
I'll second it.
I think we should discuss a little bit the rationale. What was your thinking, Andrew?
Well, it's in a secluded spot, so it's hard to see how the additional length is gonna affect any of the neighbors. It would be very detrimental and probably unsafe to have a second building because they have to, they have to have their staff available to all the residents at all times. So it would almost be like operating two separate facilities, which wouldn't be very economical. So that's the substantial justice element. And I think the other prongs they outlined well.
All right. So do we have a second on that? Yes, we do.
Second.
That was
Yep.
Mr. Harrison. Any further discussion on the motion? All in favor?
Aye.
Anyone opposed? The vote is unanimous. The variance is granted. And that brings us, I believe, to the ultimate case this evening, which we can't hear because I've lost my agenda. Oh, no, here we go. 4517, Linda Lassonde, applicant wishes to modify a previously granted variance, table of dimensional regulations under case 616, to permit an open deck with a 37-foot setback from a side property line. That was the old variance, correct?
Yes.
To now permit an enclosed mudroom and farmer's porch addition with a 35-foot side setback where a 40-foot side setback is required for property at 494 Clinton Street in an RO residential open space district. Ms. Lassonde, do you swear to tell the truth?
I do.
Would you identify yourself for the record as you testify, please?
Yep, I'm Linda Lassonde, single-family homeowner at 494 Clinton Street in Concord. It is an RO zone. Did I just kind of go for it, or?
Yes.
Okay.
Why don't you launch into it, and let's see, is this old paperwork or new paperwork?
That's the
I have the
Whitaker.
new paperwork, so I'll trade you.
All right, there you go.
Okay, so we applied for and were granted a variance back in 2016 for the existing structure and a proposed future garage. There's a 40-foot side setback. We were, we legitimized an existing addition with that variance, and we also applied for a future garage. The garage is approved for a 13-foot setback on the side. We have an existing deck on the side of the house that is 5 by 16 feet. At the time that we applied for the variance for the garage, we didn't have any intention of building a mudroom or making any other changes to the house. But we got a really good price on an estimate from our contractor. And so we decided to build a mudroom onto the side of the house. It's still not attached to the garage. The garage is still set back with the 13-foot setback. But now, instead of a 5 by 16-foot deck, we'll be building a 7 by 16-foot enclosed mudroom with a 4 by 7.5-foot porch on the back.
Can you show me on the photograph where this is going to happen?
Let's see. Okay.
Right there?
Yep. So right here, we have the the end of the house.
Right.
There's a deck right here on the side of the house, 5 by 16 foot, and we already have variances for the deck and everything on the house.
Right.
And we already have a variance to build a garage back here with a 13-foot setback. So what we're doing is we're taking off the deck and building a mudroom that's going to be 2 feet wider than the existing deck. So the existing variance is for 37-foot setback instead of 40. So we need to change it to 35-foot instead of 40.
It's a one-story house?
Well, it's a ranch that was 1 story, and we built a 2-story addition.
Okay.
So just the addition part is 2 stories.
I'd like to also point out, I
On the
believe
left-hand side.
Yeah. So,
On the southern, right
this
here.
part of the house was original. This was built in 77. This was 2003 or something. So it's a Lego house. But this part here is 2 stories. Everything else is 1.
The addition would be 1?
The addition is, the only addition that we're doing is replacing it with a mudroom.
And that would be 1 story?
Yes, 1.
and I believe on the GIS maps are in the wrong location. A GIS is not a surveyed plan. If they're actually GIS.
Garage at the same time, so we had to wait for the additional variance.
Actually build the deck, or you plan?
That's already in. I plan on keeping it that way.
Once he's
Craig changed the, it's an odd
road.
Okay.
Right there.
Yep, okay.
That's kind of weird because.
So you're gonna, when you're all done with the mudroom, you'll be
setback.
where 40 is required.
Where 40 is
40 is required. But where it abuts there, there's not a lot on that. It's an odd.
It's just it looks like someone may have made a right-of-way for a road to go back into that property years and years ago, because the place was built in the 40s.
But there's no driveway or curb cut on that.
It's actually a tree line. It's never been used. I spoke with that neighbor, and he doesn't even think it actually belongs to him, but I couldn't convince him.
Apparently the city does.
I know.
So what's that, do they have two, does 496 have, is that a second home they have back there, or what's that structure what's that structure, where the arrow is?
Where are we? Where
That's
am I?
kind of-
There's 24. That is probably, the D'Angelises have a bunch of sheds.
Which is a large shed?
Yeah, it's like a workshop, wood, because Paul had been a woodworker, cabinet maker, so he had a workshop there. And there's some other little outbuildings, but that's the main house, they're way over here. And there's the tree line between us and them, so they can't see any of this anyway.
And what about on your, is there a house on the other, on the lot next to you, that in between?
This is actually
Vacant?
the front now. This is the
Oh, I
front
see.
yard for these guys way back there in the woods.
Ah.
Yep. And this is Claire over here. And she can't see this side of her house. And somebody new just bought this house last year across the street from us. But there's no detriment to him because it's just gonna add to the property that they are.
We're on Main Street, so
We're right.
Almost on the bowl line.
Right.
You're about as far out as you can get.
Right, almost on the bowl line.
Yeah, I can actually, and I've proven it, throw a rock to bow.
you also could land an airplane on your land.
I know.
Is there a grade to that?
It's very long and narrow. Well, it actually, it goes down and then it kind of dips down and then, so it's only kind of usable up until about here.
Other questions from the board?
Like
Good,
sound
thank you.
effects?
Tanner? Did you have any questions?
No.
And I would be happy to put in a handicap parking if I have to, even though I don't need to, if it means I get to it.
I don't think we may have to let that go.
Everybody else has.
Okay.
As long as it's a real one.
Yes.
Yeah, full-sized. Any comments from code enforcement, Greg?
No, I don't have anything to add.
All right, with that, we'll close the public testimony. Record will show there was no one here to comment from the public, in the audience. We'll close the public testimony. We've heard testimony that that the land next to it is essentially undevelopable and undeveloped in that immediate vicinity. And that's about it. Discussion?
I move to approve.
I'll second.
What's your thinking, Andrew?
I imagine it's similar to why we approved the prior one. I can't recall it, but it's,
In other words,
our, it's not inter. So it doesn't really have any connection with the purpose of the ordinance.
there's certainly no harm
Yeah, no, I don't think there'll be
to
any.
outweigh the benefit to the owner.
Yeah.
On the subject of the uniqueness of the land, we have made the argument that the way a house was previously placed, in this case in the, when was it built?
1942.
Was creates a unique situation. We have a motion and a second. Is there any discussion? All in favor?
Aye.
Anyone opposed? That takes care of the regular agenda this evening. The minutes from last month.
So moved.
Is there a second?
Second.
All in favor?
Aye.
Anyone opposed? Do I hear a motion to adjourn?
So moved.
Aye.
That motion, Chris?
Yeah,
Good for you.
yeah. I know, I just voted on it.
Usually you're motionless.
Yeah, I am motionless. I'm a very